Hello, welcome to another immigration art video. My name is Art Serratelli, and together with Mara Mijal, the two of us, we are the partners over here at Serratelli Mijal, PLLC. We handle all the fun, happy immigration cases like citizenship, green cards based on work, green cards based on family, green cards based on winning the diversity lottery. We do work visas, we do visitor visas. If you've got a question, if you've got a concern, we've got an answer. Give us a call, or your best bet is email. Send us an email, and we'll go from there. Today's video is about the new and improved standards for determining whether someone qualifies for a national interest waiver self-sponsored green card. What's a self-sponsored green card? It's a green card that does not require you to have an employer. It does not require a job offer. It does not require that you have an employer sponsor you and test the labor market with something called a labor certification. You don't have to do any of that. Why? Because that stuff is for run-of-the-mill, average kind of people who do things like quality control managers in a factory. They're lawyers like me. They are pharmacists, nurses, doctors. They are accountants. They are executive chefs in restaurants. Those people have to test the labor market. You, if you're working in the national interest, we would be crazy not to give you a green card. We need you here. We need you here to make sure that your brains are being put to use for the benefit of the national interest of the United States. Recently, we've been getting a lot of email inquiries, Facebook inquiries, other social media inquiry. About what? About a case called, and I'm reading this again right off the internet. What I do is not that mysterious. The case is called In the Matter of Dhanasar, Dhanasar. Check out the next slide. I'll put a citation to it so you can double check on your own. Now, why is this case a big deal? Because, the Immigration Appeals Court issued a new decision that basically changes the three-prong test to determine who should get approved for a national interest waiver self-sponsored green card. I'm going to read you the new three-prong test, and I'll put each prong in writing on the screen after I say it, so you've got a record of it. But once you see the new three-prong test, I'm going to compare it to the old one. And you know what you're going to find out? They look very, very similar. The truth of the matter is, the new test is changing some words around and putting different emphasis on different factors in the process of determining who wins a national interest waiver case. But it's just, honestly, putting into words what everybody's been doing all along anyway since the last three-prong test was invented years ago. So is this new? Yes. Is it revolutionary? No. When you see the words that I'm going to show you and compare the two, are they very different? Are they radically new? No. Perhaps the new test makes it a little easier to win a national interest waiver case. Okay, here are the three new prongs of the national interest waiver test. You satisfy all three prongs, bingo, the green card is yours. Here we go. Number one. These phones are so small. The print is very tiny. And look at my eyes. Very, very elderly. Look at the eyes. Number one, prong number one. To get a national interest waiver case approved, you must demonstrate that the foreign national's proposed endeavor has both substantial merit and national importance. Take a look. Second prong of the test, that he or she, the national interest waiver applicant, is well positioned to advance the proposed endeavor in which the national interest skills you have are going to be exercised. Take a look. Number 3, and on balance, it would be beneficial to the United States to waive the job offer requirement and the testing of the labor market, the labor certification requirements in the approval of the national interest waiver case. There you have it. 1, 2, 3. The old 3-prong test came from another appeals court case called In the Matter of New York State Department of Transportation. And that was decided back in 1998. That test that I'm going to read to you now, it's dead, gone. But what the heck? Let's compare as an academic exercise. Let's just do it. Here's the 1998 test. Prong number 1. The petitioner must show that the area of employment proposed, again, without a job offer, without testing the labor market, you have skills and you're going to use them and you're going to do a job. The employment proposed is of substantial intrinsic merit. Here, I'll write it down. Take a look. Prong number 2. The petitioner must establish that any proposed benefit from the national interest waiver petitioner's work will be national in scope. National in scope. We used to say this means it's important. What you do is important everywhere from Alaska to Florida, from Texas to New England. Prong number 2, in writing. Take a look. And the third prong, finally, the petitioner must demonstrate that the national interest of the United States of America would be adversely affected if a labor certification were required. So this is saying you got to prove that our country will be hurt if we force you, the candidate for national interest waiver, to test the labor market. You got to prove a harm. This arguably is the biggest difference, arguably. But in practice, I promise you, it's all the same. It's all the same. I'm saying it's essentially the same. It is. Those words I just showed you, they all sound alike. It's a jumble of nonsense. True or false? Going to law school, you're figuring this out. Going to law school, it's just making something that should be very, very simple, exceedingly jumbled and complicated. As an example, let's take the criteria from the old test that says your work has to be national in scope and changing it to national importance. Your work has to be national in importance. Now, why is that? Because national in scope, like I said, it means from Alaska to Florida, from Maine to Texarkana. Perhaps you're doing something really, really, really significant in North Carolina. And it's just in North Carolina, but it has the effect of a ripple through the lake of commerce, and your ripple effect all the way to Maine, all the way to Alaska. But what you're doing basically is in North Carolina. Is that a big change? It's semantics in my book. Semantics, please. All right. The other thing it does, it changes the focus from the nature of the employment to the qualifications of the individual. What do I mean by that? The second prong of the new test states that the national interest waiver applicant is well positioned to advance the proposed endeavor. Well, that's good because we're focusing on you and your work and what's unique about you. Why should we give you the green card without having to place ads in the newspaper? What's so special about you and your qualifications? But between you and me, we did that last time under the 1998 test. We always included this. I don't care what the test was. It's all common sense. And finally, the other change, the one I've already mentioned, about showing that on balance, the waiving of the labor certification is in the national interest. That's the new test. And that replaces the old test where we had to show a harm. Arguably, this helps entrepreneurs. If you've got the right education, if you've got the right business plan, and you're in business for yourself, arguably, it's easier to show that there's a benefit to the whole country rather than demonstrating a definite negative if we force you to advertise. Again, even as I say these words, I got to think to myself, what, I'm making a mountain out of a molehill. This is all a bunch of, okay, here's my analysis. Do you want the official immigration art analysis? The immigration art analysis. It seems to me that the government, in a good faith effort to make the rules more clear and to make the three-pronged test more user-friendly, issued this new case law, and lawyers love to make a big fuss about something new. Is this new, or is this just putting lipstick on a pig? Take this with a grain of salt, but on balance, it's pretty darn good. And there you have it. And you've gotten some analysis. And I've delivered the analysis with gravitas. Do you feel the gravitas? Gravitas, the most overrated attribute required by those who are hiding behind a mystique because they're secretly afraid of being exposed as not knowing as much as they pretend they do. Gravitas. Now, do those red Western Kentucky University bobbleheads, see them back there? Do they detract from my gravitas? Does the green-headed child drawing detract from my gravitas? And you know what? Stay human, stay true to yourself, be smart, use common sense. And if you have any questions, send us an email or give us a call. Email, really, email is your best bet. We got to answer email because we get clients from all over the world. And email is the best and most efficient way to shift times. So we are on top of email. That is the best way to get in touch with us. And then we schedule phone calls from email. Okay? All right, guys. Thanks.